Good evening, and thank you for everybody for joining us this evening. For those of you joining us via the tele and virtual option, good evening as well. We are here in our St. Louis office at the MCRM Education Center, and we have with us today a great speaker who is well versed. He's been doing this for quite some time and has helped us out and helped a lot of our patients out for the entirety that MCRM has been around, which has been more than 10 years already. Tim Schlesinger. It's a very important topic if you're in any way thinking about utilizing third party, whether it's egg donor, sperm donor, donor embryos, gestational surrogate, all that is involved in that. And Tim is here to be able to help with the better understanding of what your legal rights and needs are with regards to that. If you have any questions, please free, if you're on the virtual side of things, use the question and answer section. Your questions will be asked as they populate in. For those of you here in St. Louis, please feel free to be interactive. We want this to be an interactive event so that everybody gets the most out of tonight's event. So Tim, thank you again for joining us, and the floor is yours.
Thank you, Dale. As Dale said, my name is Tim Schlesinger. I have a law firm here that is headquartered here in St. Louis, Midwest Fertility Law Group. I've been practicing law for a long time. I've been practicing law for 40 years. When I started practicing law, this field did not exist. I spent most of my career as a litigator. And I am very, very happy that I have transitioned my career into this very rewarding field. I've probably been involved in, there's almost no way to count anymore, but I would estimate that I've been involved in 1,000 surrogacies and, hundreds more egg donations and co-parentage agreements and sperm donations and anything that involves people trying to build their family through assisted reproduction. Assume everybody here knows what assisted reproduction is. But just in case, that is the act of conceiving a child outside the body. I'm here tonight to talk almost entirely about third-party assisted reproduction, and the reason for that is because people who go to a fertility clinic and go through in vitro fertilization or go through artificial insemination or intrauterine insemination, if you're undertaking one of those methods of having a child, if there's no third party involved, then for the most part, you don't need a lawyer. You have a child, let's say you go through IVF. Embryos are created in the lab. There's an embryo transfer to the uterus of the patient, and you go in and you have that baby. And in the hospital, nobody's asking you, so tell me exactly where this baby came from and what the genetics are. You don't get asked that question, so you don't need a lawyer. When you give birth to a child in that fashion and there's no third party involved, then your name or names go on the birth certificate and no attorney needs to be involved. Sometimes extraordinary things happen and attorneys get involved in those situations, but primarily tonight, I'm going to talk about all assisted reproduction situations are extraordinary, but I'm going to talk about assisted reproduction in the more routine manner that we think of it, and that hopefully you will all be able to traverse in your journeys, in your assisted reproduction journeys. So what types of assisted reproduction are we talking about? So I guess I could use my slides.
Is it not working?
That is not working. Let's see if I do it this way. How about that? Okay. So I'm going to talk about surrogacy. I'm going to talk about egg donation, sperm donation, embryo donation, co-parenting agreements. And I'm going to talk a little bit about disposition of frozen embryos, even though that might not necessarily involve third parties. Okay, so I'm going to figure out how to
When you go up to slideshow and you start your slideshow, then you can just hit the pause button and it'll click through. You see the bars at the top, file, home, insert, draw, design.
Yes, and
Slideshow.
slideshow. Will that, I don't want them to move automatically.
No, you'll hit the space bar, and when you hit the space bar, then you slide.
Okay, all right. Okay, about that. No,
It's from current slide. See up at the top where it
Okay.
says from current slide.
you know,
From
it's okay.
beginning.
It's okay. I'll just do it this way. Okay, let's talk about surrogacy first.
You just did this.
Now you just hit the space bar when you want to go to the next page.
Okay, all right.
Hit the arrow button.
Okay, all right. So let's talk about surrogacy. What is surrogacy? Surrogacy is when a woman who we'll call gestational carrier, because that's usually what we're talking about. A woman who is a gestational carrier agrees to undergo an embryo transfer to carry a child that she is not genetically related to on behalf of parents who are going to raise that child. Parents who are going to be the legal parents of that child and raise that child. You can have an intended mother and an intended father, but you don't have to. Many of my clients are same-sex couples, two intended dads, two intended moms. I do many surrogacies for single intended parents. There doesn't have to be a partner. But the people who are going to be the legal parents of the child and who are going to raise that child, those are the people we refer to as intended parents. That worked.
You're welcome.
Thank you. Who's the donor? Well, a donor there doesn't have to be a donor in a surrogacy. So I'm gonna sidetrack for a little bit. Donor is the person who donates genetic material, what we call gamete, but it's genetic material. So you're donating an egg or you're donating sperm to the person or the couple that wants to have a child. And I will also tell you, might be more than you want to know at this point, but we're evolving into situations in our field where sometimes there are more than two parents. I don't see anybody that's in more than a couple tonight, but that's also a possibility. There's no absolute restriction on it being two parents. So the recipients, if you're in an embryo donation, if you're in an egg donation, if you're in a sperm donation, the people who are receiving the material because they're going to have a child or hopefully have a child from that material, those are the recipients. So let's talk briefly, before we get into more detail about it, let's talk briefly about what is a gestational carrier agreement. So we use the terms gestational carrier agreement and gestational surrogacy agreement interchangeably. Lay people are more likely to use the word surrogacy and surrogacy agreements. I like to say gestational carrier agreement. That's because I'm a nerdy lawyer. I don't want people to be confused between what we used to call traditional and now called genetic surrogacy and gestational surrogacy. In gestational surrogacy, an embryo is formed using genetic material from either the intended parents or donors, or an intended parent and a donor. And that genetic material has no relationship to the woman who's going to carry the child. So that is a gestational carrier or a gestational surrogate. That the woman who's carrying the child has no genetic relationship to the child. There is also something that is called traditional surrogacy. In our field, we're now trying to move away from that term and call it genetic surrogacy. But in traditional or genetic surrogacy, the woman who's carrying the child is also the genetic mother of the child. We're going to talk about that more a little bit later. That's a much trickier situation than gestational surrogacy. And I would say about 1% of surrogacies are traditional surrogacies and 99% are gestational surrogacies. So if you don't like my sense of humor, I apologize for this. If you're going through third-party assisted reproduction, you have to have an attorney. If you go through, first of all, if you're going through third-party assisted reproduction, in almost every situation, you are going to be using the services of a fertility clinic, like MCRM. Every fertility clinic, every single one, will require you to have a clearance letter from a lawyer before they will proceed with third-party assisted reproduction. And a clearance letter from the lawyer says essentially, these parties have entered into this agreement. Both parties were represented by a lawyer, and they are they have agreed and signed an agreement, and now you, the clinic, you have my legal blessing to go ahead and proceed with the assisted reproduction. Let's talk a little bit about egg and sperm donation. Egg and sperm donation, especially egg donation, is more common than surrogacy. I'm going to talk about surrogacy because it's more complicated than egg and sperm donation, but you're more likely to need egg donation or sperm donation than you are likely to need a surrogate. So egg donation. It is what it sounds like. A woman who's not going to parent the child comes in and donates her egg, or eggs, excuse me. An agreement is necessary when you do that. There needs to be an agreement between the egg donor and the intended parents that sets forth in detail what the rights and the obligations are of the intended parents and what are the rights and the obligations of the donor. So I want to talk about a couple of things with regard to egg donation. The first thing I want to talk about is the concept of when the ownership of the eggs vests in the intended parents. When the way I draft my agreements, ownership of the eggs vests in the intended parents as soon as they are retrieved from the donor. So nobody can go back and change their minds and say, I want these eggs back, even if the donors even if the intended parents take those eggs and don't form embryos right away. The idea is that you want these agreements to be irrevocable. You don't want anyone to be able to change their minds. If anyone in this room ever uses me as their attorney to to help guide them through their assisted reproduction journey, you're going to see in my agreements I make really, really clear in capitals and bold lettering that nobody can change their minds. That the intended parents are the only parents of the child, and they have 100% of the parenting rights and 100% of the parenting obligations. Donors have no parenting rights and no parenting obligations. There are some exceptions to this. In Illinois, there's a statute that essentially allows the parties to change their minds before embryos are created. Once embryos are created, then nobody can change their minds. But other than Illinois, I can't think of another state that I practice in that has that law. So I always try to make my agreements so that no one can change their minds as soon as the agreement is signed. I want to talk about another issue that is very common that we deal with in egg donation agreements. I would say 95%, well, at least between 90 and 95% of the egg donation agreements that I deal with are what we call non-identified agreements. That means the donor is not identified to the intended parents, and the intended parents are not identified to the donor. I hope I won't get in trouble for saying this. Almost all of the professionals in the field, and almost all of the legal and mental health professionals in our field, virtually all of them, believe that we should no longer be providing non-identified agreements, that there's no good reason not to have the intended parents know who the donor is and the donor to know who the intended parents are. And the reason for that is because everyone agrees that if a child is born from that arrangement, then that child deserves to have as much information about their provenance, about how they came into being, as possible. Every mental health professional would tell you that it is in the child's best interest to tell the child as early as possible if they were born from a donor. I've been to many conferences in the last, especially this has really become an issue in the last 7 or 8 years. I've been to many conferences and I've been on panels and spoken with donor-conceived adults who were conceived through an egg donor or a sperm donor. And the reason they get on these panels is because it was hidden from them. And every single one of them will tell you how detrimental it has been to their life to hide this information from them. And they always find out. Yes, Sean.
I do have a question on
Okay, I
that,
can't believe you're the one asking a question. Go ahead.
but I'm going to. So I know Colorado kind of made it a mandate for their egg donors, and I believe sperm donors, to become open disclosure donors. Because of a donor conceivability group that came out and tried to mandate this. Do you see that happening in Missouri?
I don't. I think that Missouri is one of many states. Colorado is a progressive state when it comes to this type of legislation. Not everything, but I can tell you in our field, Colorado is a pretty progressive state. Missouri is not. Missouri, listen, I don't want to knock Missouri because it's really easy to get things done in Missouri. There are no laws. So we have created a process that works for everybody in all these situations. It's great. But as far as actually passing laws, mandating things like that, I think that's a long way off in Missouri and a long way off in most states.
Okay.
Eventually, probably we'll get there because all of the professionals agree that's what's in the best interest of the child. So let's suppose you go through an egg donation and a baby is born. And you tell that baby, and you don't tell the baby, but let's say your child is 5, 6, 7 years old, and you start to tell your child his or her origin story. Here is how we brought you into the world. Here's how this worked. Your child's going to be curious. And there is so much genetic information available on the internet. A 10-year-old kid could get on the internet, take a swab in his or her mouth, send it off, and track down the donor, most likely. That's how easy it is. This has changed so quickly that I was not even having this conversation with my clients 8 years ago. Wasn't even having it. It's been about 7 years. I've been having this conversation for about 7 years. That's how quickly things have changed. So now imagine to yourselves, you're going through an egg donation now, you have a baby a year from now, and 10 years from now, your child is 10 years old. That's 11 years from now. It's gone from 0 to where we are now in the last 8 years. Where is it going to be 11 years from now? I can't possibly tell you. It's impossible to predict how much genetic information will be available on the internet. The lesson I'm trying to give you here is this is not something to be afraid of. And this really applies to all assisted reproduction, not just egg donation or sperm donation, embryo donation, surrogacy. It is not something to be afraid of. These are the kinds of things you should tell your child. And I should disclose, I am not a mental health professional. I'm a lawyer. But based on my very significant experience in this field, these are things you should tell your child, how they came into the world. And your child's going to want to know, your child's going to be curious and going to want to know additional things in addition to what you've told them. Don't be afraid of that. Be prepared for it. Okay. So in an egg donation or a sperm donation, whether it's a non-identified, this is an old slide, it says anonymous. We try not to use the term anonymous anymore. But anonymous means not the non-identified type of agreement that I was talking about. Obviously, in a known donation, everybody knows, the identities are disclosed from the beginning. In any kind of a donation, the fertility clinics are going to require an agreement that says the intended parents are the legal and actual parents for all purposes. They're also going to require the agreement to say what's going to happen. I shouldn't say fertility clinics require this, but I do. What's going to happen to unused embryos that contain the eggs of the donor or the sperm of the donor? If you're forming, now there aren't, if it's a sperm donation, you're not always going to have embryos. It might be intrauterine insemination, then there are no embryos formed. If it's an egg donation, then there has to be an embryo formed. So if there are unused embryos after you're done building your family, what happens to those embryos? That's a matter of choice, but that's something that needs to be addressed in the agreement. Then when everybody signs the agreement, then we send a clearance letter, like I described before, a letter to the clinic that says an agreement has been reached, a written agreement has been reached, everyone was represented by attorneys, please feel free to proceed. If you're just going through an egg donation or a sperm donation, there's no necessity for court action. It's like I described before. You go into the hospital, you give birth to your baby. They don't ask you what are the genetics of this child. The names of the intended parents go on the birth certificate. There's no further legal action required. So let's talk a little bit about embryo donation. I'm not here to make a political or religious or philosophical statement. Some people might feel philosophically that when they receive an embryo from someone else, they are adopting that embryo. And I have no quarrel with that, in terms of whatever your personal beliefs are. Legally, however, it's not an adoption and you don't want it to be an adoption. An adoption is a specific legal process that requires a number of steps. It requires court action, and it requires third parties to get involved and a home study and all these kinds of things. Embryo donation is a private agreement between private citizens, one of whom is helping another build their family through assisted reproduction. You don't need court action for that. Again, you go to the hospital, you have your baby, your names go on the birth certificate. There are numerous different types of situations in which same-sex couples are together and have a child through assisted reproduction. So let's talk about same-sex female couples. There are a lot of, unlike same-sex male couples who really only have one option, female couples have lots of different options, and I've dealt with every single one of these. So sometimes a same-sex female couple will have, let's say they're Kate and Jane, they'll have an embryo formed using Jane's egg, and Jane's egg is implanted in Kate's uterus, and Kate carries the child. Sometimes, and I've also had this, you have both of them carrying at the same time. I'm not sure I'd choose this if I were building my family, but I've had clients who've done this, where each of them use the other's egg to be implanted in their uterus, and they each carry the other's genetic child at the same time. The reason for doing this, I'm making an assumption, but the reason for doing this is that so both parties are biologically or genetically involved in the birth of the child. You also can have a situation where let's say Jane, we use Jane's egg, and an embryo is formed, and the embryo is implanted in Jane's uterus. Okay, so Kate is not biologically or genetically related to the child. Kate's still going to be a parent of this child when we're done with what we do, but that's another possibility. Either one of them could be artificially inseminated with donor sperm, and embryos don't need to be created. So there are a lot of different methods available to same-sex female couples who want to build their families through assisted reproduction. So same-sex female couples can get their name, if they're married, and get their names on the birth certificate without any intervention by a lawyer. They don't need a lawyer. However, I strongly recommend to same-sex couples who are going through this that they go through a two-stage process. First, that they enter into a co-parentage agreement that says they're working together to bring this child into the world together. They're going to raise this child together. They're inviting each other to co-parent this child. And then after they become pregnant, then we file an action with the court, a very simple parentage action, which results in a judgment that a court issues that says both of these women are the parents of the child. The reason we do that, there's several reasons we do that. Number one, what if, heaven forbid, their relationship ends? We do not want the genetic parent to be able to say to the other parent, you're not a parent to this child. That's happened a number of times in court cases in Missouri. The law has evolved to give the non-genetic parent a way to challenge for custody, but you don't want to have to challenge just to establish that you're a parent. You want to start equally. And so that's why you want to have this co-parentage agreement and this judgment. The second reason you want to do that is if something happens to one of them, particularly if something happens to the genetic parent. So let's say Kate and Jane have a child, and Kate is the genetic parent, and Kate is killed in a car accident. Jane survives, is raising the child, and Kate's family comes in and wants to say Jane isn't a parent to the child. This child belongs to us. That's protection against that. The third reason to do this is Kate and Jane might move. Let's say Kate and Jane are living in Missouri. Right now in Missouri, I'm reasonably confident that eventually, if they got into a big fight over who was the parent, the court would say both of you are the parents. But suppose Kate and Jane move to another state. Suppose you move to another state and the law has not evolved the same way. You want to be protected wherever you go. You have a judgment of the court that says you're both the parents. That protects you. Okay, so let's talk about surrogacy. Yes.
Sorry, I didn't want us to go over and I forget my question. I did have a question. If my wife and I wanted to do a co-parenting situation with the donor, would we still need to go through the same two steps?
Yes, that's exactly the situation that I'm. So you and your wife have a sperm donor.
Mm-hmm.
You're going to, if you came to me, here's how I would handle that. The first thing I would do is before you get pregnant, I would draft a sperm donation and co-parentage agreement. So it would all be one agreement. I used to do two separate agreements, and I decided that's an unnecessary expense for everybody. Let's just do it in one agreement. So you enter into an agreement with the sperm donor, which says very clearly, you're the parent, he's not a parent, he has no obligations, he has no rights. In that same agreement, you and your wife agree that you are bringing this child into the world together and inviting each other to co-parent the child. I'm using that language deliberately because that comes out of a case that was decided in the Missouri Supreme Court. And so that's the language I use in my agreements. You're inviting each other to co-parent this child together. So that would be step one of what I would do if you came to me. I would then tell you, it is my recommendation to you to go, it's not required, but it's my recommendation to you that you also file a court action. Not a complicated action, it's not that expensive, but that you file a court action so that we end up with a judgment that says the two of you are the parents. Once you have a judgment from a court that says you guys are the parents, nobody can ever come back and say one of you isn't a parent. Either isn't a parent. So the situation you just described is exactly how I would, what I was describing before is exactly how I would handle your situation. Okay? Yes, Dale.
We have a question that's come in. I'm considering sperm donation in the state of Oklahoma as a single mom, and coincidentally, I'm currently a family law attorney. Our paternity laws here don't specifically speak to the issue, and I believe the current state of our law could potentially allow a sperm donor to seek custody visitation rights without an adoption by a partner. How effective are the contracts the donors sign with the bank?
Okay, so she's under a misapprehension. I hate to say this family law attorney in Oklahoma is wrong about this issue, but she is. There's a specific statute in Oklahoma that specifically speaks to sperm donation. And Oklahoma has, and I'm licensed in case this woman is wondering, I'm licensed in Oklahoma. I do a lot of work in Oklahoma. The Oklahoma scenario is different really than just about any other state. It actually requires you to file something with the court when you're going through a sperm donation, so that the court can approve the sperm donation. And once that is done, then the donor has absolutely no claim. And it's a really simple process. It's just a matter of filing a couple documents with the court, and getting the judge to sign those documents. But once that's done, then the intended parent, the recipient, is the parent 100%, and the donor has absolutely no parenting rights and can never come back and then claim that he has parenting rights. Yes, Sean.
Sorry, Tim.
Okay.
Um,
It's boiling again.
I know, I'm sorry. And I even turned it down to like 55 degrees in here. So to piggyback off of her question, not the one that was asked online, but this woman right here. What if it's a directed donor sperm agreement and they decide that the directed donor sperm wants to co-parent in their relationship with said child?
It's not a donor.
It's technically a donor though, if it's.
Well, it's not, okay, it may be, okay, so, it's medically, that's a donor.
Yes.
Legally, that's not really a donor. I get it.
If they're a married same-sex female couple and they have
Okay,
let's just say
you want to have 3 people with parenting rights. No, I get it.
I'm just asking because it does come up.
Okay, so you could do that. You absolutely can do that. It's got to be really, really clear in the agreement. I'd love to have that case. An agreement should be drafted that is unambiguously clear. You absolutely can do that. Whether legally we consider the donor a donor or not is kind of immaterial. Medically, obviously, that's a donor. Legally, it's a parent, at least ultimately. May start out as a donor.
Genetically speaking, it's a parent.
Yes.
Okay,
But that's a really good question.
you're welcome.
Thank you, because that was my question, but I didn't know how to like rephrase it.
Okay. Oh, I'm sorry. So I did, well, yes, you absolutely can do that. If everyone agrees that the donor is going to have parenting rights, as long as that's really clearly spelled out. And frankly, in that scenario, I would absolutely tell you, go to court and get a judgment, because that's a really unusual situation that if someone challenged it later could easily devolve into just a mess of litigation. So
Sounds like you guys need to go to Tim. His cards are on the table.
absolutely, when you are ready, please call me, or even before you're ready, I'll answer your questions. And this is, I'm not plugging myself, but it's just because of the way our field is. I want to be a resource for people. I answer questions for people all the time, even when they're nowhere near ready or they don't hire me, anything like that. That's part of what I do. To me, that's part of the privilege of doing what I do for a living. I'm so fortunate to be in an area of the law where I spend all my time helping people try to have babies. I won't tell you what I used to do, but it is so much better. You know, I'm happy to give back in that small way. In that, if you have questions about your situation, about your assisted reproduction situation, I will answer them. You don't have to hire me for that. Okay. I mean, depending on how involved they are, eventually they're going to want to get paid. Let's talk about surrogacy. Let's talk about time also. Holy moly.
It's all good, man. Take all the time you need.
Okay, all right.
We're here for you.
Surrogacy, of course, is the process of a woman carrying a pregnancy created by assisted reproduction for the sole purpose of bearing a child on behalf of someone else who will raise and parent the child. The surrogate agrees prior to becoming pregnant that she will not be a parent to the child. So, I described gestational surrogacy and traditional surrogacy earlier. In gestational surrogacy, the gestational carrier or gestational surrogate does not have any genetic relationship to the child. The surrogate or the carrier becomes pregnant through the transfer of an IVF-created embryo and carries the child for the intended parent or parents. Like I said before, 99% of surrogacies are gestational surrogacies. Actually, in my case, it's probably 99.5%. If I've been involved in 1,000 or so surrogacies, I think I've done 3 traditional surrogacies, and I got 1 right now coming up. So here's why traditional surrogacy has to come with a giant warning. It's not something, there was a point in my career when I refused to handle traditional surrogacies. I've changed my mind about that. I've changed my thinking about that. Because there are situations in which that's what works for the people involved. I mean, there are a lot of reasons for that. It's a lot cheaper to go through to have someone who's going to be your surrogate, have them become pregnant by artificial insemination. You're not paying the gestational care. You're not going through an agency. You're not finding a gestational carrier. You're not going through IVF. It's so much cheaper than gestational surrogacy. That is one reason to do it. But the reason it is so rare is because the legal risks are so high. It's got to be somebody you absolutely trust 100%. I'm now on what I think they're going to hire me, what will be my 4th traditional surrogacy. In 2 of the cases, it was the sister of the intended mother. So you can understand how it's got to be somebody you trust completely. In another case, it was a cousin. The problem with the problem with traditional surrogacy is the woman who's giving birth is not just a surrogate. She's the mother of the child. She's giving birth to the child, and she's the genetic mother. So there is no sense in which you cannot call her the mother, no legal sense in which you cannot call her the mother of the child. So what must happen in a traditional surrogacy is the mother, the woman who's going to be the mother, is going to have to adopt the child after the child is born, and the surrogate is going to have to consent to that. So it's one thing, it's a good time to talk about this. I've never had, like I said, let's say I've been involved in 1,000 surrogacies. That's a guess, it's probably low. I've never had a gestational carrier, not even close, to say anything like, gee, I regret having to give up this child, or I want to keep this child, or I have any interest at all in keeping this child. Gestational carriers simply don't do that. It's happened a handful of times in the 250 or so thousand surrogacy babies that have been born in the United States in the last 30 years. It's happened a handful of times, but it virtually never happens. The care that it's just when the child is not your genetic child and you're giving birth and you're carrying that child for someone else, you just don't have that desire. The problem in a traditional surrogacy is you're giving birth to your own child, and you know this is your own genetic child. Who can predict, once that child is born, how you are going to feel and whether or not you are going to want to keep that child? There's a famous case that was the first assisted reproduction case that most people had ever heard of, and it predates the birth of some of you in this room, but it was a case of a traditional surrogacy where the surrogate gave birth to the child and wanted to keep the child after the baby was born. And she tricked the father into, she said, just give me the child for a week. I just need the child for a week. And then I'll be fine. I'll give the child back to you. He gives her the child. She takes the child, flees to Florida. There's a manhunt. Those were the days of the National Enquirer. It's all over everywhere. Everyone knows about it. They find her at a trailer park in Florida. The sheriff's deputies are knocking on the front door, and her mother, the surrogate's mother, is standing at the front door delaying the sheriff's while the surrogate is climbing out the back with the baby. They catch her, of course. Big legal battle ensues. But this case perfectly illustrates the problem. Although the father got custody of the child, if this woman hadn't been so unstable and crazy, maybe she would have gotten custody of the child. Because at that point, the court's responsibility at that point with a mother and a father, regardless of the fact that they had a written agreement before the child was born, the court's responsibility is to determine what's in the best interest of the child. What if the court thinks the best interest of the child are to keep the child with the surrogate? Then the father doesn't get the child. And I haven't even mentioned the worst part yet. I haven't mentioned the intended mother. The reason is because the intended mother in that scenario has no rights at all. I mean, she's not a genetic parent. She's not, she's a potential step parent, or she is a step parent. She is a step parent to this child. That's where her rights end. And if any of you have ever been step parents, you know that step parents don't have legal rights to children. So those are the risks that you take when you undergo traditional surrogacy. Now, in the right scenario, if everybody has that level of trust, it's still okay. But I can tell you, as an attorney, when somebody comes into those rare times when people come to me with traditional surrogacy situations, I let them know. I say, I'm going to write you a long letter that tells you all the reasons this is a bad idea. That's to make sure that you understand and you see it in black and white. And it's also to protect me so that everybody knows I gave you this advice. And I'm not saying if traditional surrogacy became, and some clinics don't do traditional surrogacy.
We do not.
Okay. Actually, I'm going to amend that. I would say most clinics won't do traditional surrogacy because of the legal risks. They don't want to get sued either. They don't want to get involved in these big messes. And hospitals. There are hospitals that won't do traditional surrogacy. I've had that happen. And in any event, in the right circumstances, if it's right for the people involved, I have no problem with it. But everybody has to go in understanding the very serious legal risks involved. Okay, talked about that clearly. Let's talk about surrogacy agreements. So somebody comes to me and they need a surrogacy agreement. Some people think, oh, it's just going to be a simple thing, and I can tell you what needs to be in the agreement. I can write part of it for you, so you don't need to charge me your whole fee. No, it doesn't work that way. My surrogacy agreements are 35 pages, single-spaced. There's a lot of stuff that goes into that. I mean, you're bringing a child into the world, and you're bringing a child into the world in a manner in which the person who's going to give birth to the child is not going to be a parent to the child. There are a lot of things that you need to go through. There are a lot of consequences. There are a lot of potential scenarios that you need to think about. And so there are a lot of terms and provisions to these agreements. The guiding principle of the agreement, the most important thing to know is that no matter what anyone does, no matter what behavior anyone engages in, the intended parents are the parents of the child, 100%. The surrogate, the gestational carrier, has no rights to the child and has no obligations for the child. And it doesn't matter if the intended parents change their minds. It doesn't matter if the surrogate changes her mind. It doesn't matter if the intended parents get divorced or break up. It doesn't matter if somebody breaches the agreement. Suppose it's a compensated surrogacy, which most of them are. And suppose there's an agency involved and there's significant compensation. We'll just call it $50,000 base compensation. Suppose the surrogate doesn't get one dime of the compensation. And suppose, in addition to that, she's got a bunch of expenses that she had to pay that she didn't get reimbursed for. Now, none of that would ever happen. But suppose it did. It's still not her child. It doesn't matter what anyone does. It is still the child of the intended parents, no matter what anyone's behavior is. That is the fundamental guiding principle of the surrogacy. Obviously, the surrogacy agreement goes through a lot more than that. We talk about, of course, we talk about reimbursement. We get very, very detailed and specific. We talk about compensation. Those are two different things. Surrogates do not get compensated for giving up a baby. They do not get compensated for delivering a child. Surrogates get compensated for, in my view, 5 different things. They're being compensated for the risk they take in being pregnant and delivering a child. That is still a risk. That is a risk to the health of the pregnant woman. Women still die in childbirth in this country, everywhere in the world. So that's a risk the surrogate takes. She's being compensated for that. She is compensated for the restrictions on her behavior because these agreements will say, here are 100 things we're not allowing you to do while you're pregnant. She's being compensated for the disruption to her life. She's being compensated for the pain and discomfort that I will never know about, but the pain and discomfort involved in being pregnant and delivering a child. And she's being compensated also for the time and the effort she puts into hopefully caring for the child that she's carrying on behalf of intended parents. She gets compensated for all those things, and as a result, she is compensated throughout the pregnancy. I just dealt with this week. It's very rare that somebody comes to me with this, but I had a couple this week in an independent journey, so no agency was involved. And they came to me and they said, here's how we want the compensation to be structured. It's all going to get paid at the end. And I said, no, we're not doing that. Got into a big argument. But I said, we're not doing that because I understand your intentions and I don't want to offend you, but that smacks of baby selling. You can't pay for a child. You are paying the surrogate throughout the course of the pregnancy for the things that we've discussed. You're not paying for the surrogate to give up a child. So as a result, in almost every surrogacy agreement, the compensation is spaced out in equal installments or very close to equal installments throughout the pregnancy. Because if you're pregnant for 6 months, you're impacted by all these things I talked about less than if you're pregnant for 9 months. So we deal with that. We deal with where's the baby going to be born, who's going to be in the delivery room. We deal with the possibility of termination of pregnancy. I will not go through everything that I tell my clients about termination of pregnancy now, since Roe versus Wade was overturned. But it's a complicated topic that we deal with in every single agreement, in case, God forbid, a termination of pregnancy becomes appropriate under the terms of the agreement, which would usually be either to protect the health, if there's a really serious threat to the health of the pregnant woman, or if the condition of the fetus is so, if there's discovered a fetal abnormality that is so serious that the intended parents want to terminate the pregnancy. Those would be the circumstances under which a termination would be contemplated and would be appropriate under a surrogacy agreement. But it's things like that takes up an entire page, by the way. It's things like that we deal with in these surrogacy agreements. We try and think of everything we can. And over the course of the past, I would say 25 years, most of the scenarios that come up have been thought of and are now incorporated into people's surrogacy agreements. But there's a lot involved. There's really, so if you get involved in a surrogacy journey, there's really 4 steps you're going through. First, you are matched with a gestational carrier. You get medical clearance for the gestational carrier. Then you call your lawyer and he drafts a surrogacy agreement for you. Once the gestational carrier gets pregnant, in 49 out of 50 states, you then go to court to establish the parentage of the child. In Illinois, actually, there is a process where you don't have to go to court. It's a really simple process that just involves signing some documents and making sure the documents get to the hospital and the Department of Public Health before the baby is born. But everywhere else, you have to go to court to establish parentage for the intended parents. And the thing about surrogacy, the thing about the United States. So I deal with clients all over the world. My intended parents come from everywhere you can think of. I've had intended parents from every continent except Africa. They're always amazed at how the laws are different in every state. And I have to explain, and I explain this to the lawyers I work with in these other countries. We've got 52 different jurisdictions. I'm counting Puerto Rico and Washington, D.C., not counting like Midway and the Wake Islands and that stuff. We've got 52 jurisdictions, and the laws are different in every single state. And the law about how you get parentage and surrogacy differs in every single state. I'm licensed in 4 states. It's completely different in all 4 states. So I'm not going to tell you how to get parentage, but the bottom line is you go to court to get parentage so that both of the intended parents' names are on the birth certificate after the baby is born. In some states you get what are called pre-birth orders. You'll hear that term thrown around. In other states like Missouri, you can't get a pre-birth order. But in all these places, you go to court to get an order from the court that says you're both the parents. Or if it's a single intended parent, it says that single intended parent is the parent. I'm not going to go through the individual stuff because, frankly, it's necessary. Okay, let's talk just for a moment about the disposition of frozen embryos. I'm trying to teach myself pre-embryos. I'm the chair of a committee, of an American Bar Association committee that is drafting model legislation to deal with disposition of frozen pre-embryos, and we're trying to change the conversation so that people don't call them embryos anymore. They should be called pre-embryos. Technically, and if I get this medically wrong, I apologize, but a pre-embryo is what exists that gets transferred into the uterus of a woman hoping to become pregnant. It doesn't become an embryo until it's older than the 5-day-old stage that it usually is when it gets transferred. In any event, so what happens if a couple forms pre-embryos and their relationship ends? I litigated a case here in the state of Missouri. It became a very important case because the issue in the case was, is a pre-embryo a person? I took the position, I thought it was very important to this field. I took the position that a pre-embryo is not a person. A pre-embryo is property. And again, I'm not talking about something that's religious or philosophical. I'm talking about what is medical and legal. Every doctor in this field will tell you that a pre-embryo is not a person. I should say every doctor. Every doctor I've ever spoken to. It doesn't have the characteristics of a person. In any event, I'm sorry, I could talk about that for about 15 hours. But the court ruled, became a very important ruling, and allows us to do all the things we cannot do in Missouri. The court ruled that a pre-embryo is property of a special character, which was the original position of the American Society for Reproductive Medicine, taken 1990, and taken 30 some odd years ago. Since it's property of a special character and not a person, then it can be owned or possessed by people. So that if a couple forms, enters into a mutual undertaking to form embryos, by the way, I love the way you're nodding your head yes at this. If a couple enters into a mutual undertaking to form embryos for the purpose of having children, even if those embryos are not necessarily genetically related to that couple, the embryos belong to that couple, and the child that is born as a result is that couple's child, or that single parent's child, because it's their embryo that they formed for the purpose of having a child. That court ruling allows me to now go to court in Missouri for single intended parents who have no genetic connection to the child, and for couples who have no genetic connection to the child, and get a parentage judgment for the child that they're having through assisted reproduction. Sorry, I got sidetracked a little bit. So what happens when the relationship ends and the couple disagrees as to what should happen to the embryo? Well, this was the genesis of my case, and the genesis of all the other cases that have been decided in various other state Supreme Courts and courts of appeal across the country. And the question is whether or not a person can be forced to become a parent against their will. Can embryos be destroyed against the will of one of the people who formed the embryos? In brief, I will tell you that in almost every case, courts have ruled against someone who wants to have the embryos implanted to have a child against the wishes of the person who didn't want to have the child. There were only 2 cases in which courts have allowed the person who wanted to have a child to have that child, or to at least try to have the child. And in both of those cases, there were special circumstances in which in each case, it was the intended mother, and she had had a cancer diagnosis, and this would be her only opportunity to have a genetic child. And there were other factors in each one of those cases I won't bore you with. Unless you go to law school, then you can call me. I'll explain it all. But those are the only two cases in the United States in which courts have ever ruled that somebody could attempt to have a child using an embryo against the wishes of the other person who formed the embryo. In general, that's not going to be allowed. I think that's a fair summary. When you form embryos at MCRM or any other clinic, you're going to sign consent forms that deal with the disposition of embryos that you create. And one of the things those consent forms are going to ask you to decide is what happens, what you're going to choose, what happens to an embryo if we break up? What happens to an embryo if one of us dies? What happens to an embryo if both of us die? I drafted the MCRM consent forms, and I drafted them in a manner so that one person is not going to be able to have a child against the wishes of another person. I think that's the appropriate way to handle it. But there are many other clinics whose forms are different and would allow that to happen if they sign the right form at the time the embryos are created. Personally, I think this is really foolish because studies have shown that people who form embryos feel really differently about that when they form the embryo or before they form the embryos, as opposed to after having the embryos, after having children, they feel completely differently about it. And so consent forms that they sign when they're desperate to have children, when there are all these emotions going on, are different than how they would feel in the future after they have either successfully or unsuccessfully tried to build their family. In any event, those are issues to think about when you're forming embryos and the choices that you have to make. So, plug for art lawyers, you should never go through third-party assisted reproduction without consulting with an art attorney. And when I say an art attorney, terrible acronym, by the way, confuses the hell out of people. But when you consult with an art attorney, there are scenarios I can think of in third-party assisted reproduction where you don't need a lawyer, but you should at least find out. In most scenarios, in third-party assisted reproduction, and I'm emphasizing third-party, you really need a lawyer. If you're going through assisted reproduction that does not involve a third party, in most instances, you don't need a lawyer. Be careful. If you do need an attorney, don't go to your family attorney. Don't go to a family law attorney. You really need to go to an attorney experienced in this field. It doesn't have to be me. I'm really good, but it doesn't have to be me. There are a handful of attorneys in every state that do this kind of work. There are more than a handful in California and New York, but in most states, like for example, in Missouri, I know everybody. I know nearly every lawyer in this field in the United States. In Missouri, there are 4 lawyers that do this kind of work consistent. I guess 5. Okay, 5 lawyers that do this kind of work consistently. One of them's really, really slowing down and close to retiring.
Is his name Tim?
No, no. Unfortunately, I am nowhere near retiring. I should. But you should absolutely go to an attorney who is experienced in this field, and you can find them. And in fact, if you needed an attorney in some other state, you can call me and I'll tell you, here are the attorneys you can go to in that state. I know the lawyers in every single state, and I've got someone I could refer you to in every single state. I don't have anybody in Puerto Rico. I've never had anybody ask me that.
Well, you should find somebody in Puerto Rico.
I should find somebody in Puerto Rico. Anyway, but the point is someone experienced in this field, because attorneys who don't work in this field they really don't have a clue what goes on in this field and what should be in these agreements. I had a case. So just as an example, when I'm hired to represent a gestational carrier, as opposed to the intended parents, if I'm representing the gestational carrier and I'm reviewing the agreement that's been drafted by someone else, I charge a fixed fee of $2,000 in an independent journey and $1,500 in an agent. So I had a situation where there was a family law attorney, a young woman that I knew from my old days as a divorce lawyer, who was hired. She was hired by the surrogate to represent her because this was the lawyer she knew. I knew it was going to be a problem. I told my clients it was going to be a problem, but in any event, she approached it the way a traditional lawyer would, like it was adversarial, like she was, trying to negotiate the best deal for her client. Of course you are anyway, but this area of the law is very collaborative. We work together to try and reach the same result, to make sure that everybody reaches an agreement so a baby can be born. Anyway, this lawyer wanted to charge $10,000 to represent the gestational carrier, and I called her. I actually brought her to my office, and I sat her down in my conference room, and I, as nicely as I possibly could, said, "You've never done this before, and you want to charge $10,000 to represent this woman. I've done this 1,000 times, and I would be charging $2,000. Now, does that make sense to you? Let's talk through this and understand what the problems are." And she blew. And what happened was this lawyer blew the match. She blew up the match because she didn't understand how collaborative this has to be. So that's what happens that's why you need someone experienced in the field. That's the end of my slides. Yes.
You didn't really go over this. I'm not sure if you know exactly because it's kind of a little off topic, but whose medical insurance is used? Do you know?
Yes, I do. So, what scenario, what,
We would
sister-
just be using a third party surrogate with my.
oh, okay, so you have a gestational care.
I was gonna ask that question too.
Okay, all right, so, the first thing you have to do, and there are companies that do this, you can pay them to do an insurance review. The first thing you have to do is figure out whether or not her insurance, her medical insurance, will cover her maternity as a gestational carrier. You cannot ask, do you cover surrogacy? If you ask, do you cover a surrogacy, the insurance company will say no every single time because no insurance company covers surrogacy. They're not going to cover us. I won't speak to your insurance company. Most insurance companies don't cover any of the fertility treatments or anything like that. But in terms of her pregnancy, if she were having her own child, of course, her insurance company would cover her maternity. So you have to find out whether her insurance company will cover her maternity acting as a gestational carrier. If it will not, you need to find other alternatives. There are other alternatives. The Affordable Care Act mandates that insurance policies sold on the Affordable Care Act exchange must cover surrogacy. Or, I can't believe I just said that. Must cover a gestational carrier's maternity while acting as gestational carrier. And there are other policies out there that you can buy. They're expensive. I mean, there are Lloyd's of London policies.
So would we be paying her premium for?
Well, that depends on your situation.
Okay.
I don't know if this is an independent journey. I don't know if you've gone through an agency.
Okay.
So typically when I'm talking to recipients that are using a gestational carrier, I tell them, you need to speak to the gestational carrier, find out what their insurance will cover. And then at that point, take it to the attorney and say, listen, we're going to cover the premiums. We're going to cover the medical bills, put this in the agreement. And that's up to the attorneys at that point.
Now, I will tell you normally, if you came to me, you said, well, her insurance covers.
I think she's on Medicare.
Not Medicare, she would be on Medicaid.
Yeah, sorry.
I'm eligible for Medicare. Hopefully your carrier is not.
I would say, I hope you're not coming to us if that's the case.
Okay, so if she's on Medicaid, okay, that's an issue if she's going to be compensated. That's not, you've now sort of stepped into a minefield here.
You don't have to
Yeah.
say how much more about it,
Okay,
but that's an issue if she's.
yeah, if she's on Medicaid, if you're going to compensate her, she's going to get kicked off of Medicaid unless she defrauds Medicaid, which you don't want her to do. But the basic rule, the general rule is if she's got insurance that already covers her, then you're not going to pay for that because that's already her health insurance. In some agreements you do, but most of the time, no. If she has to get other insurance to cover her, you are going to pay for that because that's part of her that's part of the cost of going through the surrogacy journey, and she's not going to put up any cost of going through the surrogacy journey. A basic premise of surrogacy arrangements is that every conceivable expense that the surrogate incurs as a result of the journey is paid for by the intended parents. It's all, that's the kind of stuff you have to have listed in your agreement. And the agreement will say, we're not paying for anything that's not specifically listed in this agreement, but that's why these agreements are 35 pages. Because we try and think of everything you might have to pay.
And don't ask your clinic if what they are doing is in the agreement, because the clinic doesn't get the agreement.
Right.
They get the clearance letter. If you ever have a question about the agreement, you need to go to the attorney.
Yes, Dale.
From online, do you recommend that the gestational carrier and intended parents have the same lawyer?
No.
No.
I can say that for my personal
Hope I
experience,
said that
absolutely not.
First of all, they can't because no clinic is going to allow them to have the same. Shouldn't say no clinic. I can think of one.
No,
that's
don't even
not-
put it out there, Tim.
I'm not saying. I'm
Don't
not
put it
naming
out there.
But no is really the answer. Virtually every clinic in the United States will require a surrogate to have a separate lawyer from the intended parents, not in the same law firm, different law firms. Yes.
Hi. So can you speak a little bit on the behalf of our Oklahoma patients when it comes to gestational carrier laws
Oh, yes.
and donor sperm laws, all that fun stuff, because they are online, and
Okay,
not
so
that everybody in this room needs to hear about that, but the people online do.
except that you would need to hear about it if you ended up with a carrier in Oklahoma. So here's something everyone needs to know. The law that determines parentage in your surrogacy journey is the law where the baby's going to be born. So that's where the gestational carrier is. So it doesn't matter if you guys all live here. I don't know where everybody lives, but let's suppose you all live here in St. Louis. If your gestational carriers in Oklahoma, that's Oklahoma law. If your carriers in Nevada, that's Nevada law. That's how that works. So it's possible that more than just the Oklahoma patients could be affected by this. So let me talk about Oklahoma law real briefly. Oklahoma, believe it or not, has a surrogacy statute, which is very specific about its requirements in surrogacy. They're just hearing my voice, right, Dale? They're not seeing me, so I can walk around. The way this works in Oklahoma is different than everywhere else except Utah. The agreement and the parentage action all happen before there's an embryo transfer. So before we issue legal clearance to the clinic, we have to not only have a signed surrogacy agreement, we have to have the judge sign an order validating the surrogacy agreement. It all happens at the beginning. There's pros and cons to that. The good part of that is that if your surrogate gets pregnant, everything's done. You don't have to there's really almost no work left to be done. The bad part is you're paying for more legal work at the beginning, and you don't end up with a pregnancy than you pay for legal work that you wouldn't pay for in other states. But it sort of works both ways. And since most people end up getting pregnant, it's kind of a net positive for most people. But the the bottom line is there's a specific process you have to go through. It all gets done before the embryo transfer. 2 Oklahoma licensed lawyers are required. So there has to be an Oklahoma licensed lawyer representing the gestational carrier. There has to be an Oklahoma licensed lawyer representing the intended parent or parents. That's the way it works in Oklahoma. She wanted me also to talk about the crazy sperm donation statute. There's a sperm donation statute in Oklahoma, which I don't normally deal with because it doesn't make sense for me to deal with it. But so I'm not 100% certain, but I'm almost positive that it requires the people going through it requires a document to be filed with the court in Oklahoma that must be signed by the judge before a fertility physician in Oklahoma can perform an intrauterine insemination, which is generally what's going to happen with a sperm donation. The crazy thing about this statute is if you're going to do an embryo transfer, I mean, if you're going to form an embryo with the donated sperm, I'm not 100% sure if that statute applies. And the other thing is, even if you live in Oklahoma, if you're using a doctor that's somewhere else, the Oklahoma legislature doesn't have the power to tell a doctor in Missouri what to do. For example, if you're an MCRM patient and you come to the clinic to the office in St. Louis and have the procedure performed, the Oklahoma law, I believe, doesn't apply to that. But it's a little bit tricky, and it's something that you have to. And I'd be happy if you want to ask me about it, if you want to call me about it, I'd be happy to answer your questions about it. I haven't looked at that statute in a while, but I would look at it again and refresh my memory about the exact language and tell you what your options are.
I was gonna say, because gestational carriers became quote unquote legal in Oklahoma in 2019.
Correct.
And they became quote unquote legal in New York finally
Right.
in what, 2021?
It was
2020?
It was 2020, I think. It was maybe it been 2021. Maybe been early 2021 with that statute.
Does anybody else have any questions online, anything? Okay. Thank you guys for coming. Have a good night.
Thank you, everyone. I hope this was helpful.